Well, thank you all for coming. This is our webinar on how to comply with the new amended Earned Sick Time Act. We're going to share some slides with you guys. We're going to talk about some of the new changes, which you need to know, and then we're going to leave lots of time for questions because I'm sure lots of you have questions about your particular policies, what the changes are, how they affect you. So that being said, I'm going to share my screen here. And I'll kick it over to Cliff.
Thanks, Tony, and welcome everybody. As you may or may not know, if you haven't already gotten your Earned Sick Time Act in place, you are now engaging in illegal behavior. You're in violation of the law and you will pay a price. Well, we'll talk a little bit more about that, but that's the reality where we're at right now because enacting this law has been a masterclass in how legislation should be done. As you know, we had a bill that was supposed to go into effect last Friday, and just as you like it, they waited till about 10:40 to pass a substitute bill, and it was then posted online after 11 o'clock with a statement saying this will go into effect at 12:02 a.m. on Friday. So on Thursday night, they did that just before America, U.S. lost that hockey game. And the governor didn't even get the bill until after 12:02 and then signed it the next day around 11 o'clock in the morning, retroactively going back to what you should do. But the thought was the bill was already going to go into place. You already had to have most of these things in order, and this was actually going to reduce the requirements. So it actually gives you a little bit of an added opportunity to make sure that your policies are up to date and as good as you can be. And the effective date for everybody, unless you fall into an exception for the bill, is literally last Friday at 12:02. So everybody's supposed to be up to date. Now, originally the bill required you to provide on the 21st a notice to everybody. The state was going to develop a notice. It was going to give people the opportunity to know what their rights are in the law, what their rights were as far as to enforce this, what types of leaves they can have. And there was a notice that had been published for quite some time. Now, because the bill was changed, the effective date had to be changed on the posting because they didn't have a posting. And so we have a posting is now available by the state, but we reviewed it and it does have a little bit of an issue because there seems to be some things that aren't consistent in our view, from the firm's view, with what the changes have been. And there could be a notice opportunity. So that posting actually isn't required until 30 days from last Friday, which is March 23rd. So you have to both post and issue it to your employees. So if you're a general business with 11 or more employees, then you should be in compliance now. Period. That's the effective date of the statute. If you're a small business with 10 or less employees, you've got a little bit of time. You have until October to get into compliance, start accruing it. That doesn't mean you can't and you aren't supposed to put out the notice, the posting the state has, but as far as requirements to provide and to accrue and to start tracking time, you have a little bit of time. And if you start a new business, a new small business today or moving forward, you actually have 3 years to actually get into compliance for a small business. So there is a little bit of time for new businesses. Larger businesses need to be on top of things, and the posting needs to go out. Now, what this law does is it basically takes the old rules, which had the following. You accrue at one for every 30 hour of work, and you put that 1 hour of time off for earned sick time, and you put it into a bank for every 30 hours that it work. And no matter how many hours you work, you continue to accrue time for most employers, other than those that were below 10 employees. And that time at the end of the year, whatever wasn't used, got rolled over to the next year. And then it continued. You continue to just do it. And there are a lot of questions. Can you front load? Can you do certain things? The only thing that was in the law was there was unlimited accrual of time. So you can accrue as much time as you work. There was unlimited rollover, but there was a cap that you could use to say 72 hours of use per year. What the new law says for everybody who's a larger employer, that means 11 employees or more, is that you can simply sit down and say, okay, at the end of the year, we have two options. If I accrue time at 1 hour for every 30 hours worked, at the end of the year, I still have to roll over unused time, but I can limit that rollover to 72. So if I use a system of accrual, then I can limit the amount of time that gets rolled over to the next year, and I can still have a 72-hour cap per year of usage. So that's very important because we used to have unlimited usage and a giant bank potentially, but now we know no matter how much time you get, there's a limit on that. Now, the new statute actually gives you a little bit more freedom if you're a large employer. You can actually front load. You can front load 72 hours at the beginning of a benefit year. If you do that, you don't have to roll it over. You don't have to roll over that time. So that's good. So that's a accrual and cap that's different based on the amount of time you use. If you're a smaller employer, this is very important. You can accrue one for every 30 hours, and at the end of the year, whatever they don't use, they can accrue and roll over to the next year up to 40 hours. And you can cap at 40 hours of usage per benefit year. Or you could front load time to 40 at the beginning of the benefit year and then allow them to use that 40 hours and not accrue and not take notes on how many hours they're actually working, and you don't have to let them carry it over. So small employers at 40, large employers at 72. There's a carryover cap for everybody, depending on whether you're a large employer or a small employer. The front loading is very beneficial. Okay, so you want the front loading to understanding your policy, what you have. And there's actually a provision in this new rule or new law that allows you to say, look, if I have a part-time employee, I can look in good faith and look back and say, I think this person is going to work 20 hours. And I'm going to go ahead and basically front load, if they work 20 hours at one for every 30 hours worked, here's how much time they would have. And I can front load them with that partial front loading. So that gives you a lot of opportunity if you're front loading people with a part-time to not have to give them full 72 because they're going to work less. And you just think about, okay, this is what I think they're going to use. I give that up front. And as long as they work that, you're in good shape. You can go ahead and you can limit the rollover to nothing. However, unlike what you do when you get 72 hours in a front load for a large employer, you actually have to still track hours. And if that employee actually works more than you thought they were going to work, then you have to add it to their bank. So a little bit different. So it gives you an opportunity to partially compensate somebody for hours if you know they're not going to work one for 30 without having to give them that full 72 if they're only a part-time worker, but you still have to track. As long as you give them that good faith estimate up front, you still aren't going to have to roll over the time, even if you have to adjust because of the hours worked. And one of the biggest things that we've seen that have come through as far as questions that people have is, do I need to have a separate bank, or can I just combine this with my PTO, my vacation, or my sick time bank that I already have in place, or the one that I had already put in place for this ESTA that was supposed to go into place? And the answer is yes. You can combine ESTA into a bank that you use for other types of leaves. So for instance, I could have what I would consider to be a slush fund. You have time. You can use it for ESTA qualified reasons. You can use it for vacation. You can use it for personal time. You can use it for non-ESTA qualified absences, whatever mix you want. But once you do that, once you use that as a combined PTO bank, if you do an accrual method, you're going to have to carry over that time. It is extremely difficult to be able to mix and match within one bank and only carry over so much ESTA. So it's very important that we understand that the front loading that we're going to have to do for PTO, not to have to carry it over, is still going to be 72 hours. So you can combine different types of leave. And if a person uses all their time up for vacation and then at the end of the year has a problem that might be STA qualified, but they have no time left in their combined bank, then it's not going to be paid time under the PTO policy because they've exhausted all that time. So again, what the law does is allow you to have some flexibility. You still can shave it off into its own policy. You could have an ESTA only policy or a sick policy, or you can have a combined policy. So a lot of flexibility here, but those are the general rules and dynamics of the accrual system, the carryover system, and what type of system you can use for doing it. So you can use your existing policy, sand some edges, put it together, or you can define a brand new policy if you want. The key is to make it effective last Friday, right? So that's very important to make sure that we have that. Some places are going to have a problem. They're going to say, well, what about it? I'm in the middle of the year. I don't know. You could develop a policy that says, look, for this year, we're going to accrue. And then at the end of the year, you get to carry your time over. But then beginning next year, we're going to front load, but you front load plus whatever you accrued. The following year, if you give the 72 or the 40 hours up front, then you start going by the rules that allow you not to roll over unless you want. You can always give more time. You can always allow people to use more than 72, but that is the limit. Think of minimum wage. Now, Tony, I think you have a couple ideas you want to go through.
Yep. So, continuing to talk about some of the changes, this law applies to all Michigan employers, and it applies to nearly all Michigan employees. So in the previous version of the law, the only exception for employees was as to federal government workers. Under the new version of the law, unpaid interns are now exempt. And there's also a kind of strangely worded exemption for workers that can set their own hours. And I want to read the language. So it says, an individual that works under a policy that allows them to schedule their own working hours, and there's a policy of the employer that prohibits the employer from taking adverse personnel action if the individual does not schedule a minimum amount of working hours. So what that means, we don't have any additional guidance right now. We don't, so there's some FAQs on Leo's website. I would caution taking a broad view of this exception. We don't really know who this is aimed at right now, but it's probably not going to apply to people who just can show up whenever they want, right? I think that last portion of the statute that says the employer's policy against taking personnel action if they don't schedule the minimum working hours, I think that's going to be the key part if you're analyzing an employee and seeing if they fall under this exception. But beyond that, there's no employee exemptions. Temporary, seasonal employees, they will fall under this law. It still does not apply to independent contractors, true independent contractors, but that's a different question. Just make sure you're classifying your employees properly. Another change is that in the previous version of the law, we had that probationary period where if an employee is hired, they'll start to accrue the time, but you can limit their use of time until 90 days after their date of hire. That probationary period is now extended to 120 days. So you hire someone, you can now have them wait until the 121st day of employment before they can use any paid earned sick leave. So that's one change. Another clarification that I think is good that came out of the amended law is that the new law clarified that overtime, holiday pay, bonuses, commissions, supplemental pay, those aren't included in the calculation of normal hourly wage when you're trying to figure out how much to pay employees. So this comes into effect when you've got, per mile truckers or, workers that aren't paid in a traditional manner like hourly or salary. So if you'll recall, the law says that you need to look at the pay period in the period before they want to use earned sick time and basically come up with an hourly wage. And what this new change is saying is that you're not going to take into account overtime, holiday pay, bonuses when you try to come up with that normal hourly wage. So I think that was a good clarification there. And then there's also new notice language. So under the ESTA, you can require that employees give you notice, at least 7 days notice if the need for earned sick time is foreseeable. So if someone's getting a wisdom tooth taken out, you're scheduling that appointment months in advance. You can require the employee give you at least 7 days notice. Now, under the old version of the law, we had the language in there that if it's not foreseeable, the employee has to give you notice that's as soon as practicable. Now that's still in there, but they added an additional wrinkle. And the additional wrinkle is that if the need for earned sick time is not foreseeable, you have the notice that's as soon as practicable, or you can require employees give you notice pursuant to a written policy regarding how they're supposed to give you notice um, uh, of their use or want to need or their use of earned sick time. So what you can do now essentially is you can draft a policy that says, you have to give me notice if you're going to use earned sick time, at least X amount of hours before your shift or something like that. If you do that, you can enforce that notice policy. So it gives employers a little bit more leeway. If you have special conditions where, you require X amount of people at work, or, you don't want to get jammed up and someone tells you last minute and now you don't have someone to cover a shift that day. So I think that's what it's aimed at. So an additional sort of tool in your toolbox that you can use now. As for documentation, we've talked about this before where employers can't ask for reasonable documentation proving the need for sick time until the employee has used 3 consecutive days. That's still in there. And then the language that the employer is still on the hook for out-of-pocket expenses associated with getting that doctor's note or whatever it is, that's still in there as well. The only change is that if you do require that doctor's note or reasonable documentation, the employee must provide you that documentation within 15 days. We didn't have that time frame before. So, I think a helpful change there for employers. And then another change is that under the previous version, we had that 6 month window where if an employee was separated or terminated or left for whatever reason, and then they come back within 6 months, they were entitled to keep their accrued but unused time. Now that time frame is decreased to 2 months. So if an employee leaves or is separated for whatever reason, and the employer doesn't pay out the value of that unused sick time, and then they come back within 2 months, they're permitted to keep that time. So those are some additional changes there. I see we have a bunch of questions in the chat, but we'll get those after we go through one more slide, which I think Mike is going to take.
Thanks, Tony. Yeah, there are quite a few questions, so I'll try and keep my comments short so that we can get to the questions that are in the chat box and the Q&A. But there's a couple of important things on the enforcement of the ESTA that was changed in the final version. One is that it specifically indicated that adverse action may be taken if there's misuse or a violation of the notice requirement. There was some concern previously that if employees don't have to give notice unless it's 3 days and they can do whatever they want, and then there was a retaliation provision that said there was a presumption that if any adverse action was taken within a certain period of time after use of sick leave under the ESTA, there's a presumption that it was unlawful. So under the retaliation provision, there was a thought that any action against an employee that took sick leave may be presumptively or in fact illegal. They cleaned that up a little bit. They said, no, if there's misuse or if there's specific violation of notice requirements, then you can enforce your normal disciplinary policies as you would in any other situation. And there is one issue with this notice requirement. Previously, the notice was 7 days if it's foreseeable, and as soon as practicable if it was not foreseeable. The final ESTA changes that a little bit, and it says it's as soon as practicable, or you can follow your existing policy on your notice requirements. There's some conditions. You have to let the employee know, you have to give them a copy of it, let them know what the notice requirements are. But if you do that, then you can enforce your normal established notice policy requirements. And I think that's important because they changed the adverse action and tweaked, I guess, the notice requirements to allow you to follow your policy. So that gives a little more control, I think, over guarding against abuse of sick time whenever anybody doesn't want to come to work. And what I just said, the rebuttable presumption is now gone, and there's also no private right of action. Previously, the thought was that there was going to be a considerable amount of mistakes that ended up in class action lawsuits, which I think was a real concern. The change was, let's not turn this into class action litigation immediately. Let's allow this to be enforced the way a lot of employment and wage laws have always been enforced. That's through the wage and hour division. So that's where the enforcement now goes. The penalties are just $1,000 for any retaliatory action. Of course, you don't want to take retaliatory action, but they set that specifically. And then failing to provide sick leave, what is the harm? It's 8 times hourly wage for failing to provide sick leave. And then there's $100 for violation of notice posting. As Cliff said at the beginning, this law took effect last Friday. The notice posting requirement has a 30-day window period, but the notice has to go up in that 30-day window, or you may be triggering this violation on the notice posting. And I think there's a problem with the notice posting. The last notice I saw from the wage and hour division still had the private right of action in it. Notice that employees could file a private claim. That is not currently the law as implemented. So I think that notice has to be changed or corrected by the wage and hour division. So when you post that notice, make sure that it's the corrected notice. Otherwise, I think you might be posting rights employees allegedly have under the new notice that don't in fact exist. And then there's with collective bargaining agreements, I don't want to get into constitutional law, but there's a constitutional prohibition on any legislation that impedes existing contracts. That's always been the case with collective bargaining agreements. That is the case here. There was some discussion over does the collective bargaining agreement address the sick leave as required now by statute? If not, does it really impede? But for most of the collective bargaining agreements that have any type of paid leave time, the ESTA is not going to take effect until the expiration of that collective bargaining agreement. And the expiration date is as printed on the collective bargaining agreement now. It's not, we'll extend it, we'll get up to it, we'll have a continuation day to day or for a specific period. That doesn't count. It's the expiration date as written into the current collective bargaining agreement. And when that expires, then the compliance with the ESTA must come in. Then you have individual employment contracts. It's still the same issue, the impeding contracts through legislation. Interestingly, and I don't know exactly where this came from, but the ESTA says if you have an individual employment contract that provides for sick time, different than the ESTA, the contract will prevail, but there's an effective date. That individual employment contract has to be effective as of the end of last year. So they went retroactive on that a little bit. I'm not sure where that comes from, but that's what I'm reading. Maybe that's litigation waiting to happen. But if you have individual employment contracts that specifically address sick leave or paid time off, you might want to take a look at whether that individual employment contract takes precedent over the ESTA, at least until the individual employment contract expires, which can be no longer than 3 years in its duration. So those are the big issues on the enforceability. I know there's now I think 65 questions in the chat and additional 19 in the Q&A. So I think I'll throw this back to Tony and Cliff. I'm not sure exactly how we're going to address these questions, but we will try to address as many as we can with the time we have remaining.
Perfect. I can read some of these off. And I know we got some in the chat and some in the Q&A. I don't know if we're going to be able to get through all 90 questions in the next 30 minutes, but we'll do the best that we can. And I'm going to bounce in between the chat and the Q&A. And I'll toss it out to Cliff and Mike, and I'll jump in myself as well. So one question we got is, if an employer, as part of our PTO policy, pays out unused balance at termination, will that satisfy the requirement to not restore previous balance if rehired within 2 months? Cliff, you want to take that one? You're muted, Cliff.
Sorry about that, Tony. Yes, that's actually something they addressed in this revised version of the bill, which wasn't there before. If you've already paid out the time, you don't have to reload the bank. If you decide not to pay people out, because you don't have to, right? Part of the law is once you earn the time, you get to get the time. But when a person is terminated or leaves, it's up to you to pay them out any unused time. So if they come back within 2 months, they get that money back. If you've already paid them out, then they just start to accrue again. They've already got the benefit of it when they came back. So that's a good thing that they changed in this revision.
Next one we have is, I'll throw this to Mike. What's the status of firefighters? They're occasional employees. They work in a regular schedule, generally for a few hours a month. Are they included in the ESTA or not?
Well, that's a question I have been getting a lot. And the provision that was added Friday, or I guess late Thursday night, and what became the ESTA may come into play, and that's employees that can schedule their own hours, provided that if they don't pick anything up, that it doesn't have any adverse action, meaning they'll be taken off the list or whatnot. But I think that firefighters are included in the definition of employee entitled to sick leave. So you might get into a situation where they are not employees at all. They may have de minimis pay that does not translate into a requirement to report it on the W-2 or pay taxes on it. So you might have a de minimis issue that could kick into here. But if you have the regular paid on call, they pick up a sufficient amount of work to get paid, reported on a W-2, then my reading of it is that they will be entitled to 1 hour for every 30 hours of on-call time they pick up.
Perfect. The next Q&A question that I can take is the previous paid medical leave. What happens to that time that employees have earned? Does that go away? Does it need to be paid out? Unfortunately, we're starting a new law on February 21st of this year. You're going to have to comply with that law. Any time that you've provided under either the Paid Medical Leave Act or your own policies, obviously it depends on the situation, but under the Paid Medical Leave Act, you don't have to pay that time out unless you wrote that in your policies. If you had a policy to pay out, unused vacation time and you're planning on restarting that, then you may have to pay it out, but there's no requirement that you pay out the paid medical leave or sick leave under the Paid Medical Leave Act. Got one here for Cliff. Are trustees of a board considered employees?
Well, from the statute itself, it's a bit unclear, but What we've seen from the Wage and Hour Department is some FAQs, and they have said generally, no, elected officials are not going to be the individuals that are covered employees for ESTA, even if they're paid like a stipend. Now, if you treat that person as an individual employee in some other respect, that could change whether or not they're employees. But if they're simply just an elected official or member of a board, they're generally not going to be included. That's what the Wage and Hour Department has put out. That's consistent with their original FAQs they put out, because the definition is so broad of what an employee is that I think, when we originally saw it, you could definitely see that was the case, that they were. But this is the position that labor or the Wage and Hour Department has taken.
Mike, we got a question here that says, we sent the notice last Wednesday, and we had our notice posted in a space in each building. Do we have to send out a new notice to everyone?
And by notice, I'm not sure, there's two types of notices under the ESTA. One is a posting that is required, and then one might be a policy or other notice. My position, and I think that we agree that the posting of the notice that is prepared by the Wage and Hour Division is mandatory, and that must be posted. If that's the notice we're talking about here, the one that was posted last Wednesday is not going to be compliant with the new law, because neither is the draft that currently exists. So once you have a notice that's prepared by the Wage and Hour Division that is fully compliant with the ESTA requirements, and again, that includes the enforcement mechanisms, then that has to be posted. That's within 30 days. So I would watch for the updated corrected notice and then repost. With respect to a separate policy, it really depends on if you want to change or drill in maybe with more detail on what is being provided other than what's mentioned in the notice posting. And if there is, you should have a separate notification to the employees. It can be in a handbook, it can be in a handout, it can be probably by email, but separate notice, anything that's separate from the notice posting that you want to enforce, you have to provide the employees with those additional requirements or specific policies for that business. And if you do that, you should do that also within this 30-day period.
Hey, just to follow up on that, Mike, real quick, if you go online to the Labor and Economic Bureau's website, michigan.gov, and that's called LEO a lot, they
Right.
actually have a copy of that posting, and it's required to be posted. And they also require you to, like Mike was saying, give out notices of individual employees' rights. And there's some rights and some obligations that are on there more than just posting it, but you can see the posting there. And if you have more than 10% Spanish speaking employees, they also require you to give it in that language as well. So just be cognizant of that fact, that there should be both English and potentially different languages. And they've got postings that they're put up, and they're available. You can print them out, you can put them up there and send them out that way.
Perfect. Got a question here. Is front loading recommended? If you front load, are you required to comply with the 3-year record retention to show what hours were used for ESTA purposes? So just as a kind of general caveat, we can't talk about your specific situations. We can give you, general information. Whether front loaded is recommended for you versus someone else, it's always going to depend on your business. I think generally front loading may not be recommended if you have part-time employees who may accrue less. But now we have new front-loading benefits. You have the ability to front-load part-time employees so long as you make sure that you don't shortchange them. So these are considerations that you'll need to make as a business, policy considerations. And if you do front-load, you are not required to track or calculate accruals. And again, you don't have to carry over anymore.
But the one thing to make sure, when we say you don't have to track accrual of time if you front load it, you still have an obligation to track usage. So make sure you are putting in place a mechanism to allow you to say, Johnny and Susie, took this many hours of ESTA qualified absences if you're using a PTO or an all-in-one program to make sure you're doing that properly. So those records are required to be kept. And I think it's important to understand there's accrual of time and then there's use of time. When you front load, you don't have to do the accrual discussion of how many hours they did because you gave them that at least 72. If you give them more, that's fine too. But if you are still allowing people to use it, you need to track time used for 3 years, keep the records, make sure you have them.
Yep. All right. Cliff, we got a question here. We'll say it generally, if you front load before the effective date of this law, does that count towards the new requirement?
It could. So let's just take it like this. Everybody's a little bit different. It depends on your policy, but let's just say you give January to December year of a benefit, right? So I get to use my vacation or my sick time from January 1, December 31st. I gave you 72, maybe I gave you 80 hours. You can use it any way you want, or you can use it for sick time, including the types of absences that ESTA covers. So long as you have that in place by the 21st, and that's your year, yeah, you're in compliance. You're doing exactly what the law wants you to do. So that's great. So if you've already done it and you're already ready to go, this law doesn't want to take away from that. It's not trying to add 72 hours on top of that. It's just trying to make sure that you're in play. Where the concern would be is, how do I handle it if I didn't do it by the 21st, or I'm not going to do it until June, or if I do it on an anniversary year and the person doesn't quite have their anniversary year yet. So let's just say, for instance, effective the 1st, I was going to front load everybody once their anniversary year hit. And you have people that are hired throughout the entire calendar year. That's not going to be in compliance with front loading because you haven't given them the time from the 21st, which is when you had to do it. So you have to do something to fill that gap to make sure they're getting either accrual rates until they hit that anniversary year later on in the year after the 21st, or you're going to have to bump them up, but you got to do it consistently. So whatever you do, you got to fill that gap in. So yes, if you already did it and it's compliant and it continues to be compliant, but you have to look at the particulars.
Okay, Tony, while we're on front loading, I just noticed one that fits into here is from Sherry that says if you front load, you have to give all employees 72 hours regardless of whether they are part-time or full-time. That's an excellent question because that's one of the changes that was made at the 11th hour under the prior versions of HB 4002, which became the STA now. It was 72 across the board that didn't provide for a lesser amount for part-time. The current law, though, changed that, and it does address part-time. And what it allows is for front loading of part-time for the company or the employer to estimate the amount of time that is expected to be worked during the benefit year. But then you need to track that usage. As Cliff was saying, it's critical that you track the usage because if you guessed a little bit low or the employee worked more than expected when it was front loaded, once that amount that was front loaded is used up and there's still some additional accruals based on the hours worked, then you're going to have to supplement what you front loaded. But that under the ESTA as it was implemented is specifically permitted.
Perfect. Thanks, Mike. And I think that hit Amber's question as well about front loading. Do you have to load in 72 despite any hours worked? So no, you can separate full-time versus part-time and front load less, exactly like Mike said. Mike, I'm going to come back to you. Are owners included in the employee count?
Our employers included in
Are owners of a
Owners.
business included in the employee count to determine a small employer?
I haven't specifically looked at that. Maybe I'm going to defer to Cliff on that because we talked about how you count that, but I'm not sure I've seen the actual term owner in that uh, math, if you will.
Right. I think that that's exactly where we are in a lot of these haven't been defined. This is considered a green law, right? It's brand new. There's a lot of gray area. Looking at the definition of who's an employee, they don't exclude owners. So we have to start with that idea, right? And it's very broad. It's anybody who's, in the scope of, performing services like the business. I mean, it's really, really broad. So if I own a company and I'm passively involved, I just literally put money into it. I do nothing, absolutely nothing other than just simply sit back and own it. That's one analysis, which we don't have an answer for, but you probably would be clean if you're not making decisions because you would be more like a board member, right? We talked about elected officials, a little bit different, but it's somebody who's just simply sitting back and attending a meeting versus somebody who's the owner who's involved with the operations. The more you're involved, the more likely you're employee. So I would be reticent to tell you not to include an owner in 99% of the situations that come about because I don't know how you can own an operation, especially if it's small, right? If you're trying to figure out if you're large or not large, if you're an owner of a company and you take part in that company's running and its operations, even not day to day, but just general scope of business, I would say this would include because of the broad definition of employer. That's not settled law yet. There is no FAQ on that. The rule just came out. We don't have an interpretation on a number of issues, but I believe most small business owners are going to have enough of their control that they're going to be an employee for purposes of counting. But that's us taking a bit of an educated stab in the dark on something that was not defined other than employee is broad. It's extremely broad. And I would believe that they should fall under there. A court someday may disagree, or labor and employment subdivision here at the state might say, no, they're not. But most of the time, if you're in a small business, especially, you are taking a hands-on approach. You are going to be doing enough of the work to be an employee. Now, again, every definition is different. There are actually certain laws that exempt owners from being an employee in other situations, but that's because their definitions are different. They're excluded. That's not the case here. There's nothing excluding them either in this rule and any regulation, because there was no regulation yet on this law. So that's where we stand right now.
Yeah, and on that point, there's an FAQ that was put out there, and this was specifically towards publicly appointed boards and commissions. Um, the department says they're not covered, but then there's a caveat at the end that says unless the governing entity treats these individuals as employees. So
Right.
I think that goes exactly to what Cliff is saying, is that, well, there's a little leeway here that, it depends on the situation. All right. I've got a question. Can we code any use of PTO as ESTA time? Again, you can use a combined policy so long as you're providing at least as much time as required under the ESTA, under the same conditions. So that's permitted, but it depends on your policy, and whether or not you have enough in the bank when this goes into effect, and you're complying with the portions of this law.
But if you have a sick time policy in and of itself that says everything here is ESTA, then that's easy. Everything is ESTA. But if you don't and you have a combined policy, you're going to want a separate code.
Yeah.
Right. And I think that gets us into the area of do you need a separate sick time bank? And the answer is no. You can combine them into a PTO that includes time for any purposes, including those under the ESTA. I don't uh, know that there would be a prohibition on coding it. I don't see the purpose for it if it's a combined PTO, because the issue and the question I get a lot is what if you front load 72 hours, somebody goes on a vacation a month later, they exhaust the 72 hours on vacation and then they get sick. Does that matter? And the answer is no. They had it, they could have used it for anything. You do not have to supplement because it was not used for sick. So by coding it, I don't think accomplishes anything. The question is, did you have sufficient paid time in the bank to meet the requirements of the ESTA? And if yes, did the employee use the available time? It doesn't ask the next question, why did they use it? It's did they use the time that was available for any purposes, including ESTA? So you can code it if you want, but I don't think you need to comply with ESTA.
Perfect. Next question we have, and there's some specifics in here, but I'll keep it general. So with regard to the exception and whether that applies to employees that control their own schedule, I think we can just sort of talk generally about this and who it may apply to. We have a question about a paid straight commission and agricultural workers about, they schedule their own time. So I can jump in here real quick. So I do want to read that exemption. So again, there's an exemption now for workers if the employer has a policy and both of these conditions are met. One, the policy allows the individual to schedule the individual's own working hours. And two, the policy prohibits the employer from taking adverse personnel action against the individual if the individual does not schedule a minimum number of working hours. So if you have that policy and your policy says I won't take adverse personnel action against a worker if they schedule 0 hours throughout the entire year, you may fall under that exemption. But again, we don't have any additional guidance on it right now. We don't know who this is aimed at. We don't know if it's at, volunteer firefighters or agricultural workers. Like I said, I would just caution a broad reading of that exemption.
So let's just get down to what a lot of places would like to do. I've got a high level manager or, some exempt person in the company. And we're like, look, just get the job done. I don't care when you work. I don't care if you ever come in the office, just get the job done. People would say, well, look, I don't really care if you come in or not. I don't really care when you work. I just need you to get the job done whenever or wherever it is. My reading without anything from the courts is be very careful on that because there's an implied requirement that person gets something done. That is different than I have a list of temporary employees or casual employees. And on that casual list, you can pick up a shift here, there, or anywhere whenever you want. But if you don't pick any up, that's fine. We're not going to kick you off the list. That is not in my reading of this what they're looking at. But again, we haven't had this tested. Now, if anybody would like to test that, that's fine, but you do it with a lot of potential penalties if the person doesn't get that time and they do an audit and you saw there are penalties for not doing it. But just be careful in understanding what the intent of this appears to be. The intent appears to be people who are not going to be penalized if they ever work for you, but will be paid when they do come to work for you. Not somebody who's getting a job done whenever they want to. Hey, pick a day, any 5 days you like. And if you don't want to come in on a Friday, that's fine with me, is not what they're saying. If you remove somebody from a list, if they don't pick up so many shifts or pick up so many days of work, that's going to get you going. Then the next step is, are you qualified if I don't care when or if you ever come in from a manager or an executive level or a salesperson or whatever it is? I caution people not to try to be too cute with these things until someone else has been either successful in doing that or been bitten in litigation, because you will be the test case. And if you want to be the test case, call us up. We'll help you out. We'll go down there. We'll fight as long as you've got the money to spend to fight it. But just be wary. Just be wary on that one.
Perfect. Cliff, I'll come back to you. If someone accrued 72 hours in year one, didn't use any, and then the next year, can they accrue another 72 to carry over a total of 144?
Half that's right, and the other half no. So year one, Johnny works. Johnny is a great worker. He comes every day. He's never missing a day, gets 72 hours. He's never sick. He never takes time off. He's a company man. You know, he's the kind of guy you like. At the end of the year, carry over 72 hours because he's got it in his bank. Next year, he starts off day one. He's got 72 in his bank to use. Not over time, but 72 to use right then. Then he gets with it again. And he works every day. Company man that he is, never calls off, never sick, never has a problem. End of the year, he's got 144 banked or whatever he's got banked, right? So at that point in time, he gets to carry over 72 because the most that you minimally have to let him take his 72. Now, you could allow him to carry more over if you like. You could let him take all of it. That's your policy decision. But the minimum that we're allowed to hit him with is a carryover of 72. So that's the key. Interestingly enough, though, let's imagine year one, Johnny works like a dog, never takes a day off. He gets a 72 on year two, and he takes off a couple weeks, right? He takes off a couple weeks and eats into that 72 hours. And so he's got 3 hours left or something like that. But then he works a lot of overtime and accrues and accumulates another 72. His bank then has the 3 plus the 72. He's got 75 at that point in time. If you put the minimum 72, he can carry 72, even though he already used some of that time. So he used some time during the year, but still gets to carry over 72. Sometimes people are saying, well, is it just a combination of use plus what's left over? And the answer is no. If I've got a bank of 72 at the end of the year, and that's what my max is, that's what I'm allowed to carry over. If I only got 10, then I only get to carry over 10. But it's not just if you don't use time, you get to carry over 72, regardless of how much time you use in a year. You can set the limit at 72 that can be used in the year. But if I use 72 and still have 72 in my bank, I get to carry that 72 over to the next year. But what I'm not going to get is a massive bank of time that I get to accumulate over time, unless as a company, we want to do that. And that's a decision you can make. That's something that some companies do allow. Now, it's really interesting. There's nothing directly in the statute that says you can just pay them out instead of letting them carry it over. It doesn't say that anywhere in the statute, but the state's FAQ says you can do that. And that's different than what we had before, but it literally says under the new version, you have to let them carry over 72 unless you pay them out. Now, it doesn't say unless you pay them out a week or 20 hours, and then you can take the rest of it over. It says unless you pay them out their accumulated time. So that's what it's saying right now. So that's important to know. That's what they've said. You know, you can infer it from the statute, but it's not in the statute, but that's what they do allow you to do.
Yep. We got a question here. If you front load, do you have to give all employees 72 hours? I can take this one quickly. So we've talked about this one a little bit. You can front load less for part-time employees, so long as you're estimating the amount of hours that they're going to work in a year, and then you're keeping track to make sure that you don't shortchange them. And if you do give them less than they're entitled to, you're making up that ground. Mike, I'll come to you with this one. For large businesses using the accrual model, does the 72-hour rollover expire after 2 months of separation? So if someone leaves employment, they're gone for longer than 2 months, do they retain any of their time?
That 2 month was a change from the prior requirement, so it reduced the amount of time. And this ties into when you separate from employment and you have time in your sick leave bank or PTO bank, depending on how you structure it. So you have time that has been accrued and not used. What happens to it? And the rules, there's two. One is you do not have to pay it out. If you choose to pay it out, you can, but you do not have to. If you choose to pay it out and then the person is rehired down the road, you do not have to reinstate it because it's already been paid out. If you don't pay it out, then and then you rehire that person, what happens to the time they had in the bank, the 72 hours? And the question is it within the 2 month period? If so, it gets reinstated in the bank. If not, it does not. You must start accruing as a new employee.
So let me just follow up on that with a little bit broader discussion. Imagine you've got a vacation PTO bank that says every year that you work, you get a little bit more vacation, you get a little more PTO, right? So I've been here for 1 year, I'm going to get 72 hours. I've been here for 10 years, I'm going to get 3 weeks or 4 weeks. That's absolutely fine if you add this ESTA language into that bank. And you can say, look, even though the minimum that you can use during a year is 72, I'm going to allow you to use this amount per year. Person has a nice bank, you let them continue to bank their time. Let's just say the time that they resign from your employment, they're a 10-year employee and they've got 4 weeks and you let them have 4 weeks, but they haven't used it because they get it at the beginning of the year. Your policy will tell you one of two things. One, you're going to get none of it or some of it based on whether you resign with notice or something like that. Or it's going to say that you get paid out. Okay. Or you get paid out nothing. Okay. So you get nothing or you get something. It's one of those two. And what happens is whatever's left over, if there is anything left over in your bank, if you come back within 2 months, you get to continue to use it. If you come back in 3 months, again, you're not required. It's up to you. You could reinstate it. You don't have to. And there's actually an FAQ that says just shipping somebody from one group within your giant employer to another doesn't extinguish them so that they don't have that right. If they come back, if you just send them, they don't have to start accruing again. They get to continue that whole bank. So just a couple things to think about in line of what Mike was talking about with that 2 months. That's different, but it's still the same concept. If a person comes back in 2 months, they're not going to make them start over again from scratch unless you already paid them out.
Yeah, and that raises a good point. Just a real quick additional point on that is we're talking primarily ESTA because that's the topic of the day. That's what everybody's interested in. But we're also talking about written policy.
Yep.
And the written policy has to have a minimum compliance with the ESTA. It can go beyond. So under the Michigan Wages and Fringe Benefits Act, fringe benefits, which is leave time, is enforced as written. So you have to comply minimally with the ESTA. If you go beyond the ESTA in a written policy, that additional benefit under the policy is enforceable under long-established Michigan law.
Well, that's a great point, Mike, and that leads me into one of the questions that we got. So one question is, do you have to have a written policy, keep records, and give notice to employees under the ESTA? I can pose that to both of you guys.
Yeah, Cliff and I have been debating this for since last Friday. So, Cliff, I'll let you jump on this one.
Yeah, this is what Mike and I have talked about. At the very minimum, you've got to give the notice posting out, which tells you what the limits are of the law. But you've got to have a policy, even if it's not in writing yet, you've got to have a policy that you follow that's at least the minimum and consistent with the law, period. Having said that, it doesn't make sense not to have a written policy in case you get challenged. And so when the original ESTA was going to go into place, when it was going to happen last Friday, the thought was just put the notice that the state put together, put that out there to give employees the notice of, here are your rights for accrual, here are your rights for use, here are the types of leaves that you can have, and here is the type of penalty and what you can do if you don't feel that's being followed. Period. Right? That's the minimum you have to do. That is a policy. That's telling them what we do. But it's not telling them which one you're doing. Are you front loading? Are you accruing? Are you going to let them take their time when they leave? Or are you not letting them take their time? So that's when you start drafting up your policy. When is your benefit year is the only thing you really have to tell them in the notice posting. If you take a look at the state website and the posting they drafted, at the very top, there's a blank. It says, when do we start? What's your year? Is your benefit year for time off January 1 to December 31st? Is it your fiscal year? Is it your anniversary year? Really, that's the writing that starts your policy. But I think as we've talked about it, ultimately you're going to have something in place from a policy standpoint that you're going to have to follow. What I worry about when you don't have a written policy that you formulate is that there will be different managers on different days doing different things, and that runs into a potential problem. But at a minimum, you've got to have the notice of what your rights and what your eligibility is. But then you've got to have a policy that you actually do. I would recommend you put it into writing once you figure out which way you want to do it. That way it's consistent and everybody knows what it is, period. So that's sort of where we're at. I like the policy idea. I like getting it done. And there's nothing stopping you from changing it. It's not working. Right down the road, you notice, well, we gave everybody front loaded this year. Everybody took their time in the first 2 months, and then they were all crying and complaining because they had no time left when they actually needed it the rest of the year. Okay, well, maybe we'll go to accrual next year, and we'll go ahead and we'll change that starting something in the future.
Right, and don't lose sight of, I think, an important issue, and that is you still need to run a business. In running a business, you still need to schedule employees to work. You still need to get shifts covered and, what it takes to get the product or the services done, which is why you exist. I said earlier that the ESTA now allows you to put into a policy requirements and enforce a policy on notice, even if it's unforeseeable. If all you do is post the notice, you don't have the benefit of that policy that's unique to your business. So you can have a policy that says you have to call the department manager, your immediate supervisor, HR, whatever the policy requires, and you can enforce that. If you don't have a policy telling employees what the notice requirements are, then you don't have any notice requirement that you can enforce.
Well, we're 5 minutes after. What do you say we go for another 10 minutes? And then if we're probably not going to be able to get through all of the questions, but we'll put in myself, Cliff, and Mike's emails into the chat as well. And you can follow up with us individually if you have additional questions.
Hey, Tony, I would like to, there's a couple of them out there about front loading, and just to make sure everybody understands. So the effective date of the law was last Friday, right? And so when people ask, when does front loading start? Can I do it now versus doing it, back that way? Well, from a technical standpoint, your policy was supposed to be compliant as of the 21st, period. End of story. If you're not in compliance, you're not in compliance. So if you front load today, technically you missed the deadline to front load it. That doesn't mean you can't have a policy that goes back to Friday and says effective Friday, this is how many hours everybody will have, at least 72. If you say starting on March 1st, we're going to do 72, right? And then every year after that or whatever, that's fine, but you're going to have a catch-all. And I think I saw a couple different versions of that issue, but the law started when the law started. They wanted you to have a policy in place to make sure that you have a front load. That front load had to be either in place on or before the 21st or be effective. And so if anybody had some sort of absence that would have been covered that they otherwise didn't have money for in their bank, to have money for it. You could have converted your old system. People had lots of money in it and just said, hey, for those people who started between January and February 21st, we're going to retrofit that and bring everybody up, so long as it doesn't compromise anybody's ability to utilize that time, not be disciplined, and have that. That's fine too. So you can retrofit it, you can retrograde it, but you got to make sure that no one gets disciplined if that's what you're going to do or has been disciplined because of a qualified absence.
I've seen a version of this question a few times as well. Can you treat certain employees differently and have some accrue and have some front load?
I believe you can in certain circumstances. So for instance, I've got two employees, they both do exactly the same job. job A, or, the person, I like the most, I give them an accrual, and the person B who I don't like, I do it a different way. No, I don't think that's going to be applicable. But if I have office staff that's salary exempt, and then I've got people that are hourly, or I've got people who work out in the field versus people who work mostly, in an office. Yeah, I think that there's a legitimate reason to have a policy that's the same anniversary year, but the accrual is a little bit different. Again, you don't want to have a piecemeal policy where everybody's getting different things, but there are times and circumstances where different jobs, different responsibilities would allow you to have a system. But you've got to be sophisticated enough to be able to understand that just because you do it differently for two different groups, that now you're going to have to track and accrue and accumulate time differently. So it's going to make your life a lot more complicated too.
Yeah, and there's one in here, I think it's a different question, but along the same line. What if you do a hybrid of front loading for most, and for employees with less than 2 years, you have them accrue time? So you have two different systems depending on how long they've been there. Do we have to carry over and track the employees years 1 and 2? The answer is yes, you can have two different systems depending on objective factors, which would include years of employment, particularly since if they're part-time, you can front load if you choose to do that after the second year based on the estimated hours. How do you estimate it? You say, we want to accrue for the first year or the first 2 years, and then we'll go forward with front loading. That makes sense, and I don't see anything in the ESTA that would prevent that. So I think that is permissible. With respect to the carryover, it doesn't matter on the limits on carryover if it's front loaded or if it's accrued, unless you pay it out. Yeah, it's particularly if you accrue it and then you have time in the bank and then you switch over to front loading in year 3. If you have time from year 2 that was accrued and not used, you're going to have to comply with the carryover of 72 hours.
Mhm.
For up to 72 hours.
I did see one question here, and I think it's important to address. Um, Karen said that the word nonprofits was taken out.
It
Does this
was.
still apply to nonprofits?
I mean, Mike, you and I and Tony and a few of our other attorneys have debated this one since Friday. Look, I don't know why they took it out. It could have been because the actual term wasn't nonprofit. The actual term was a little bit different than nonprofit. It had nonprofit in it, but what we look at is the two sentences in that section. The first sentence says, here's what an employer is, and it says corporations, limited liability companies, and a whole bunch of other things. And it had nonprofit agencies, I believe it said, and they struck that out. And then it continued, and at the end it said, or any other entity that employs one or more employees. Well, nonprofits still, most unless you have no employees, nonprofit companies or whatever you have still employ one or more employees, period. And then the next sentence says that the employer does not include the United States government. It doesn't say it doesn't include nonprofits. So they didn't change it from being in the first sentence of inclusions to put it into the exclusion. So the problem here is I think a lot of people looked at it right away and were like, oh, they're out. And I hope they are out. But there's no guidance saying they're out. In fact, the statute, the way it's written, still has that catch-all saying, yeah, even though we struck that line, whatever a nonprofit agency is, because it's not defined in the statute, it still says any other entity employing one or more employees, and it isn't listed in the exclusions in the very next sentence. So I think you're taking a very risky position to believe that they're not covered, because if you're wrong, and if I was a judge, which I'm not, but if I was a judge and I was looking at this or I was waging out, I would say, show me why I should exclude you if you have one or more employees and you're not the United States government.
Right. And you got to be very, very careful with the terminology here as well, because nonprofit is really a tax issue, comes out of the Internal Revenue Code. And nobody here is a tax attorney, so I'm not going to pretend to give tax advice. But nonprofit, I don't think gets you where you want to go, because governments, cities, villages, townships, whatnot, they don't pay taxes, federal taxes at least. And so technically they're nonprofit, but they're included as government entities. They're specifically included in the ESTA. Corporations can be nonprofit corporations. Corporations are specifically included in the ESTA. So the language that was struck was nonprofit agencies. And nonprofit agencies is sort of a general term, almost a term of art. I don't know. It's not defined in the ESTA, and I'm not sure it's really defined anywhere that is helpful here. So, is there a nonprofit agency that the legislature was thinking about when they struck that and said we don't want them covered? Maybe, but they didn't give any indication that's what they were thinking about. Or was that considered to be a term that did not have meaning, so they struck it to make it more inclusive of saying all corporations, all government entities, everybody except for the U.S. government is included. And there's a lot of discussion that I've seen that believes that's what the legislature did.
Hey, Tony, here's one that I saw a number of different things in there. How do we figure the wage for a farm worker or truck driver and all these specialized areas of the law that comes up pretty routinely? We've seen a number of these come up and we've had some discussions about it. They did revise, as you were talking about, the way we do the wage rate. There was actually a catch-all in the initial version that said, well, go back and take a look at, the last, some, period of time and average it out. But now we have this new version, which actually basically has like, two parts. It's either one or the other. It's either normal hourly wage or base wage or minimum wage. Where are we at right now? And I think this is one of those, we have to wait and see gray areas. I mean, frankly, because they did change the catch-all and threw it out. They actually struck out the catch-all that we used to have for these type of industries.
Yeah, they struck out the catch-all. They still include that language in there that says, look at the pay period before the pay period in which the employee wants to use sick leave. So for per mile truckers, for ag workers, where it's not a traditional manner of paying them, you got to use the tools that you have. If you're tracking, hours worked in some manner, and you're tracking how much you're paying them, you got to come up with a normal hourly wage. That's the phrase that's used. Now they include additional language in there that says you're not going to use overtime pay, you're not going to use bonuses, commissions for determining what that normal hourly wage is. But yeah, like you said, we don't have guidance on what exactly that means. My best advice would be to use the tools that you have, figure out how much you're paying employees, look at that pay period before, and try to come up to that, normal hourly wage, to figure out what they would have received, and figure out how much you need to pay them if they're going to use 8 hours of sick leave or 2 days of sick leave. So until we have additional guidance, not crystal clear, but I think that's your best bet.
And that's the best that we can do right now. I think Tony's right. I agree with what he just said. It's just there are going to be areas where we pay people where they really did not do this. If you look around the country to similar type laws, everybody's a bit different, but California doesn't define, for instance, in their sick pay law, how to handle over the road truckers or people in certain groups that get paid differently. But we do know what we exclude, right? We have the exclusions of commissions and the exclusions of tips and gratuities in the calculation. So that helps us. And when we take a look at it, so we do the best we can to figure out what is the base wage, what is it that we're paying this person, let's get it to them. And so again, it's not supposed to be a windfall. And remember, if a person gets a commission and they're out, they'll probably get the commission when they come back. If they get their piecemeal while they're out, they'll get it when they come back. But what do they miss for that base rate. That's all they're really trying to compensate for that person for that day. And we'll have some guidance. I'm sure we'll have some cases, we'll have some guidance that are going to come out. We just don't have those 100% yet.
Perfect. All right, well, we're at 12:18, 3 minutes beyond what I said. Still have a ton of questions. Just wanted to thank everyone for showing up, for being engaged, asking all of these questions. We wish we could cover them all, but unfortunately, we don't have 3 hours today. But I put my email and Cliff and Mike's email in the chat. You can also find our bios at the Foster Swift website. Feel free to reach out to any of us if you have additional questions or need help on your particular situation. And just thank you again as we work to figure out all this new stuff. Happy to help everyone out. Those are my final comments. I don't know if Mike and Cliff, you had anything additional.
I just want to thank everybody for joining us. A lot of moving parts still. The wage and hour division still looking at it. I've been talking to them on a couple of these issues. They are updating their FAQs, so that's a good place to watch. Our website, obviously, we're going to put updates on it. So, just as things develop, just try and keep up on it, do the best you can, and I think we can all get through this.